be sign in and get food or anything like that. My name is Mathews V. I'm a staff attorney here at Chicago Volunteer Legal Services. We are a pro bono-based legal aid organization, which is a bit unique. From the very beginning, we've been using volunteer attorneys to handle the majority of our cases. And that's partially, I hope, why you're here. We provide free training for all of our volunteers. If you want CLE credit, there's a sign-in sheet that people are lying behind. You can write down your name and your contact information. Make sure you include your email, because that's how we would send your CLE certificate. So make sure that's there. At the end of the training, we also have some evaluation forms that you can fill out. Let us know how we did, what was helpful, what was not helpful, and how we can improve. And then finally, I just have some contact information for myself at the top of the outline for today's presentation. I see that my fax number I got wrong. That's not going to work. So it's 312-332-1460. So I'm going to give you kind of a quick preview of what access to justice is, because that's where these cases are litigated within our own organization. First of all, CVLS, like I said, is a volunteer-based organization. Within that organization, there are a lot of different programs to get people who need legal help in the hands of competent pro bono volunteers. The program I am in is called Access to Justice, which is a Chancery Court Annex referral program. So courts and Chancery can see someone who is low income and needs an attorney and enter a referral order that will send that person over to our organization. Then we use great law students to process those intakes, write up the legal problems that are facing the person, and then we go into court about a month later to tell the judge whether we can accept the appointment or not. If we do, we place it with a volunteer attorney, perhaps one of you, who picks up representation throughout the rest of the case. It's a great program because we get to partner with the court to do something that I think everyone wants to happen, and that's have everyone equally represented in these cases. So that's the program that I'm in. The cases that are heard in Chancery are administrative review, which is the subject matter we're handling today, and foreclosures, and contract disputes and preliminary injunctions and things like that. So right now we're just going to start with admin review. If at any time we're going through the training, you have a question about anything we're talking about, just raise your hand. Since we are also online, I'm going to have to repeat your question so that the microphone can pick it up and then people can hear what the question was and what the response was. I really do want this to be as interactive as possible. So if ever you have even an inkling of a question, raise your hand and we'll kind of talk through it. You can kind of see a short outline that we have at the beginning. We are going to use Chicago Housing Authority cases as kind of examples throughout the training so you can understand the way that the law works in this area. So right off the bat, I'm not going to go through and read this verbatim, obviously. I think that would be a waste of your time. There's a lot of citations to different cases, some statutes and things like that that can be helpful later on. If you do have one of these cases, you can kind of go back and refresh yourself on some of the authority. An administrative agency is a government body that is not a court or an executive branch or the legislative branch. It is kind of a mashup of all three in one. They are creatures of statute, so there is an enacting statute that's been passed by the legislature that starts some kind of new program or benefit or regulatory scheme or something like that. Statute gives the overall guidelines for the program, the outlines of what the legislature wants, and then usually it either creates an agency or refers that regulatory scheme or program to an agency to run. So the agency can only act within the authority given to it by that statute. If it acts outside of that authority, then it's beyond its jurisdiction, and that activity can be reversed. As an agency, and we can all kind of think of agencies, the Secretary of State, the Chicago Housing Authority, the Environmental Protection Agency, the Social Security Administration. All of these organizations are not legislatures, they're not courts, they're not, the executive branch. They are all three rolled into one, and they have a lot of control over our lives and the benefits that we get. The IRS, any of those things are all administrative agencies. They've all been created by some enacting statute by a legislature, and they're all there to run some kind of program or regulatory scheme. So, administrative review is what someone does when they believe that an agency has acted unlawfully. Perhaps they've stepped outside of their authority given to them by the statute. Perhaps they are not following their regulations the way that they should. Perhaps they're just picking on someone and doing something that has no relationship to, the facts of the case. But what an administrative action basically is suing the agency in court, asking a judge to step in and correct the agency's action, and to have them follow their administrative plan. So I guess I kind of skipped over a lot of information, but you can kind of see in the first section, the nature of an administrative agency, what kind of authority the Chicago Housing Authority has. First of all, it was enacted by the Housing Act of 1937. That's the federal enacting statute that starts the program for public assisted housing. That statute then created the Department of Housing and Urban Development, HUD, which is then charged with running the public housing program. Then HUD institutes its own federal regulations as to how this program should be run and deputizes local housing authorities, such as the Chicago Housing Authority. The Chicago Housing Authority then creates its own administrative plan that is approved by HUD, and then that is how the program here in Chicago is supposed to run. So you can kind of see the hierarchy of authority going all the way from the Housing Act of 1937 all the way through the administrative plan of the Chicago Housing Authority. And that kind of goes from the most authority and the most broad, with the largest paint strokes for any particular regulatory scheme, all the way through the least authoritative but the most specific with the Chicago Housing Authority's administrative plan. So one example I have here is, in the original statute, it's supposed to be based on the person's income for the aid to receive. Okay, well, what is income and how are we supposed to get income? The statute is not going to speak to that. So the legislature defers to HUD and say, okay, HUD, come up with some regulations about what is income and how the tenant is supposed to get his income. Okay. Then HUD enacts a regulation, kind of like a legislature, and says, this is what we consider to be income, this is how we're going to collect income. Now, housing authorities, go forth and collect this information so we can calculate income. And then the housing authorities say, okay, here in our own administrative plan is how we're going to get that income, that information, and calculate what the tenant's income is. So you can kind of see from the most broad, the most authoritative down through the most specific, but the least authoritative. Does anyone have any questions about that, about the kind of the hierarchy of the authority for the enacting statute on down? Okay, great. So, kind of back to the actual lawsuit. If an agency has done something that you believe is unlawful or made some kind of a mistake, you can sue them in court and say, Your Honor, please step in and reverse this agency's action. The way that we get our cases at CVLS is there's a help desk on the Chancery floor called the Chicago Legal Clinic. And if someone has, let's say, their housing voucher terminated, there's a notice on the bottom of that termination notice saying you have the right to file a action to reverse this in the daily center of the courthouse. They can go over there with the help of the Chicago Legal Clinic and their Chancery advice desk, file the petition, and that's how the case gets started. The judge will then refer that case over to us for representation moving forward. So that's kind of how these cases get started.
Earlier stage of exhausting administrative.
Right.
You're going to talk about that?
Yes, yeah. So basically, I'll get to that in just a moment. There was a question about exhausting your administrative remedy, and that will be coming up real shortly. So basically, there's two sources of procedure for administrative review actions. There's the administrative review law, which is an actual statute, It has very strict deadlines about when you need to file these complaints. And there's the common law writ of certiorari, which is just, Your Honor, use your equitable powers and stop this government body from doing this to me. So the way to tell is whether the enacting statute has adopted the administrative review law or not. If it has, the administrative review law applies, and those timing deadlines go into effect. If the enacting statute doesn't, then common law writ of certiorari applies, and the deadlines are a lot more lax. The standards of review are still identical for how the judge is supposed to, decide whether the agency has created some kind of mistake. So for the Chicago Housing Authority, that enacting statute has not adopted the administrative review law. So we review cases for the Chicago Housing Authority by writ of certiorari. The reason that's important is because the administrative review law only gives you 35 days to file your complaint for judicial review. If you don't file it within 35 days and add all the necessary parties, the court lacks subject matter jurisdiction and the case has to be dismissed. If it's by writ of certiorari, you have 6 months, which is a lot more time to file your complaint for judicial review and add everybody. And there's a few other minor differences between the two, but that's the major one, is we have these really hard timing deadlines. The other thing you need to know for administrative review actions is you have to exhaust your administrative remedies. If you don't, the court is without subject matter jurisdiction and the case has to be dismissed. So exhausting your administrative remedies basically means that you run it up the flagpole within the administrative agency. So let's say that I get a letter from the Secretary of State telling me that my driver's license is going to be suspended. I can't file a complaint for judicial review on that letter. I have to call the Secretary and try to fix it within the Secretary's own procedures. If the Secretary has a complaint form, I have to fill out that complaint form. Then if the Secretary has a hearing, I have to go to that hearing. If it goes against me and the Secretary has an appeals department, I have to go to that appeals department. I basically have to do every mode of I have to pursue any form of remedy within the agency that the agency provides for me. So for the Chicago Housing Authority, the highest you can get is an informal hearing. Some administrative agencies have a lot further. Some actually have formal hearings that are on the record and are a lot more structured than an informal hearing. But all you need to do is exhaust the remedies that the agency has provided for you. Does that all make sense? Okay. So at the CHA, the way the case would start for someone is they'll get a letter in the mail saying, we found out that your son was engaged in drug-related criminal activity. He was arrested on the state with a bag of marijuana in his pocket. We are seeking to terminate your housing assistance. Then our client would need to request an informal hearing at the CHA about that issue. They will then attend the informal hearing, present their case as best as they can. They probably don't realize the level of the stakes because it's deemed an informal hearing, and actually it should be handled as a trial and present as much evidence as you possibly can and preserve any kind of objections you have to what they're presenting. They don't do any of that most likely. It goes against them, and that is as far as they can get within the Chicago Housing Authority. After they've done that, then they can go into court if it's gone against them and seek judicial review. Other agencies, like for Social Security, which we don't handle federal benefits, you have a lot further that you can go and have a formal hearing that's on the record, and it's much more structured than an informal hearing. So those are kind of the main things you need to have in order to have subject matter jurisdiction. Is you need to have filed your complaints on time, and you need to have exhausted your administrative remedies. The complaint itself is not like other complaints that we're used to. It's not going to allege a whole bunch of facts that need to be admitted or denied. It simply has to allege that you are a party to an agency action that has harmed you in some way, and make a request that the agency file the administrative record, and the relief that you're seeking is that the court reverse the agency's decision. And you have to attach the actual decision to your complaint, but that's it. You just have to allege, I was harmed by this agency, their action was unlawful, here's the decision I'm asking to be reversed. I ask that the agency file the record with the court, And that's about it. The response to that complaint isn't, admit, deny, whatever it is. It's simply the agency filing the administrative record with the court. So what the court is now going to do is review that administrative record and decide whether the agency at the highest level made a mistake, of law, of fact, or other kind of mistake. So the only evidence that's going to be presented in this case is what was originally presented at the informal hearing at the agency. So if our client was at a CHA informal hearing about this criminal activity and they didn't present any evidence besides their own testimony, they can't come into court now and say, oh, and Your Honor, look, the case was dismissed. I have a letter from my son, and here's a letter from his probation officer, and all these other things. You can't get any of that evidence in because it wasn't before the agency when they made that decision. So they're not going to be faulted for coming to a decision without all the evidence in front of them. So it's limited to the administrative record. If our client for some reason believes that they did present evidence at that hearing that has not been included in the record, you can simply amend it, hopefully by stipulation of the parties, and include that evidence before the court. So we have the complaint, we have the record on file. The next thing that our client would probably want to do, and may have tried to do with the Chicago Legal Clinic over at the help desk in the Daly Center, is file a motion for a temporary restraining order. A lot of our clients, again, are coming from the Chicago Housing Authority. They're on the Section 8 Housing Voucher Program. And the way the program works is our client has a private lease contract with the landlord that is then subsidized with assistance from the Chicago Housing Authority. The landlord and the Chicago Housing Authority have their own separate contract. So our client is contractually obligated to pay full rent, regardless of whether the landlord is receiving that subsidy. And if our client doesn't pay full rent, the landlord can file an eviction action, and there will be no defense in that action to say that the CHA was supposed to pay part of the rent. So a temporary restraining order is basically, hopefully imposed to continue to keep that benefit flowing during the actual lawsuit. If it's not, our client could be severely harmed, and if she has to wait all the way to the end of her case, by then it might be 3, 4, 5, 6 months later. That's 6 months without the benefit, without the rent. Maybe it's someone who had a home care worker that they needed and was provided by DHS. 5 or 6 months without a home care worker, if you're severely disabled, could be really hurtful. So at the beginning of the case, as soon as possible, we would try to file a motion for a temporary restraining order. And, I think there's 4 elements of a to get a TRO. They're in the outline: irreparable injury and likelihood of success and all those kinds of things. The biggest issue usually is whether there's a likelihood of success on the merits, because all the others are pretty easy. I mean, if our client doesn't get the housing voucher, they're going to be homeless. They can't wait until the end of the lawsuit to see whether they get their voucher back or not. They owe a private landlord rent right now. So all these things kind of fit the first 3 elements of a TRO. The only one that's usually at issue is, Your Honor, do they even have a shot? So a likelihood of success on the merits, all you have to show is you have a good faith argument to give the court that she could succeed on. It doesn't have to be an ace in the hole. All you have to say is, look, Your Honor, this is what we intend to present. It's enough to win. If the judge agrees with you, it's not a ruling on the merits. She doesn't say, yeah, you're going to win this whole lawsuit. But it's at least enough to keep the benefit in place while the lawsuit is going on. If you wait for too long to file a motion for a TRO, it no longer becomes a temporary restraining order, because the temporary restraining order is there to preserve the status quo, which, if you file it right after the benefit was terminated, is to keep the benefit flowing. That is the last peaceable state between the parties, is kind of what a TRO is for. If you wait 6 months or a year after the benefit is terminated, you're no longer maintaining the status quo. You're asking to get back in the program now. And that becomes a mandatory injunction, which is a much higher burden of proof to get. You have to show that your right is I think, free of any doubt, or that you have a clearly, I don't know, the language is in the outline, but you have to show an extreme emergency. It's a drastic measure. Suddenly all these adjectives are in the case law about how you should not get this thing and how judges should not give it this to you, except in the most extreme circumstances. So you want to file a motion for a TRO as soon as possible to show, Your Honor, we're not asking for them to get back in the program, we just want them to stay in the program until we have a final decision on the merits of it. Hopefully, you're granted the TRO. If you're not, you just simply need to make a phone call to the landlord and say, look, sorry, can you hang tight and not try to evict this person while we're trying to get this voucher back? We are kind of on the same side. We want you to get paid. So hold off. If you evict a person, you're not going to get anything. If we win, you might get the back rent that was owed during this period. So hopefully the landlord's a good person and wants to work with you to keep the person in the unit. It's harder for other benefits. You know, if someone needs it paid, it's really hard for them to go without. And you might want to consider shortening the briefing schedule so you can get the case over with as quickly as possible to get that benefit back. Hopefully win on the merits. So, do you have any questions about restraining orders, what that looks like? It shouldn't be. So, if it's an emergency motion for a temporary restraining order, you can only not notify the other party if the circumstances allow that to happen. And that would have to be in your motion. So Your Honor, I mean, notice for the other side is usually, what is it, by rule 4 days or something, by mail notice. I should think that you could provide notice to the other side without, like, you know, the house isn't on fire or something like that. If you're trying to get a TRO without the other side, the burden of proof jacks up, and it suddenly now has to be verified and supported by an affidavit about why you can't give notice to the other side, and only then it will only be in effect until the other side gets in there and can contest the TRO. So there's really no sense in trying to get one ex parte because it's so much harder, and it only is a matter of days until you can actually get one with notice, and then the burden of proof goes down. In our cases, we don't file the motions for a TRO. The people who do it at the Chancery desk don't technically represent these people. They don't give legal advice. They're just there to help them fill out forms. So it may not be the most robust motion that I've ever seen drafted. It may be kind of vague because they don't know what to put in the motion and they don't have an attorney to give them advice about what's to be in there. Fortunately, like, the judges who are referring these cases to us are hopefully receptive to the arguments we have and may look past some technical defects in the motion. Some of the common arguments I've heard is, Your Honor, this isn't maintaining the status quo. Status quo is they're out of the program. Our response is the status quo is the last peaceable or actual peaceable state between the parties. That would be before they sought to terminate this person from the program. Other things they've raised is usually the motions aren't verified. They're not supported by an affidavit. They only need to be verified and supported in an affidavit if you're seeking an injunction without notice to the other side. We have notice they're here, so no need to have it verified and supported by affidavit. Would it have been nice if it was verified and supported by an affidavit? Like, yeah, it would. But it wasn't our motion. We picked it up and we're just running with it. If it gets denied for the somewhat more vague motion, nothing's going to stop you from coming back later and having a beefed up motion for a temporary restraining order. You should still do it as soon as possible, but the fact that the judge denied it on a more vague motion doesn't mean you can't grant it on a more robust motion later. You know, it's not reclusive. Does that answer your question?
Yeah. Can you take an appeal?
Yeah, the question is if you lose a TRO, can you appeal? I guess, yeah, if injunctive relief is an appealable order, I don't know if it's your motion but denied whether you can appeal that right away or if it's granted if only the other side has the right to appeal it. Does anyone know the answer to that question? Do you have to be hopefully we'll have your contact information, we can get you an answer, but I could think if it was granted against you, I think that gives you the right to an automatic appeal. I don't know if it's your motion and you lose whether you have the right to appeal it right away. I think for our cases, I've never had any reason to want to appeal it so quickly because the case is going to be over in 2 or 3 months anyway, you know, shorter than any appeal, and by then we'll know whether we've won on the merits or not. So for the cases that you might be seeing through our organization, I doubt there's going to be any kind of an appeal, or at least at that stage of the game. So That's through motions for a TRO. There is a slight difference between the administrative review law and common law. The standard under administrative review law is for good cause shown, which arguably is a lesser standard than the common law writ. But I haven't litigated that personally. I don't know if there is a real difference or not. There's an argument to be made that there is. Again, if you want an emergency motion, you can still do an emergency motion with notice to the other side and just go to the court's chambers and ask for the next available court date by an emergency. If you do that, you're going to have to include in your motion what the basis of the emergency is. For a Section 8 CHA case, it would be that this landlord is owed rent, and if he doesn't get it, he might file an eviction action. That's, in my mind, an emergency, and we don't want to wait until the next court date is spindled up in the clerk's office. We want a court date now and have it heard as soon as possible. Once all that is done, the court will enter a briefing schedule. And this is kind of where the rest of the training is about. So we have the complaint, we have the record, we have any motions that have been granted or denied. The briefing schedule now is where you argue to the judge why the administrative agency should be reversed. It is just like an appeal, which makes it really fun. The record is closed. There's not going to be any discovery, which is great. No drawn-out motion practice. All it is, Your Honor, here are the mistakes that they've made with citations to the administrative record. Usually you get about a month to file your brief. The limit is 15 pages by court rule. If you want more, you can ask leave of court when you get the briefing. Extraordinary issue that requires a huge constitutional argument. I don't know. Usually 15 pages should be enough for anyone. After you file your brief in support, they have their response saying why your brief in support is full of crap, and then you have your reply to say, no, Your Honor, they're full of crap and we were right the first time. Since it's your case, you get to file the first brief. Same thing if it's your motion. You get to speak first and you get the last word. For the brief in support, the format I usually like to have, I was at training recently that kind of said, it reminded me that judges care most about, what was it? Primacy and recency. That you remember those two things most. What was the first thing that you said? What was the last thing that you said? Is what judges usually remember. So, in the introduction, just a nice cap about this poor family that's going to be thrown out because Junior was at the wrong place at the wrong time and had half a gram of pot in his pocket, and now you're going to kick out a family of 5 with 3 kids that are 10 years old out in the street. Well, that doesn't sound right, so you can do the introduction about why you should win this case, give a preview of your legal argument, and then you can move through into the applicable law section. Chances are this judge is not personally familiar with all the different regulations that might cover this program. And because administrative review could handle any government agency with its own set of regulations. So you're going to have to educate the judge about what the regulations are that govern this program and why the agency got it wrong in their regulations. So, if it concerns terminating a family's voucher because of family criminal activity, there are regulations about that. You can cite to the federal regulations, the HUD guidebook, the CHA administrative plan, explain exactly what the rules are for that particular issue, and lay it out so the judge can see it for herself. You also probably should attach copies of the administrative plan as exhibits, because the federal regulations are publicly available, and I think a judge should know how to look up a federal regulation. But the judge may not know where to find the administrative plan, which should be posted somewhere online, but some of the agencies who have a really hard time finding where their administrative plan is, and I know judges, if they don't have it in their courtesy copies, will just have to Google it and find it for themselves and page through. So it's usually better to just be the helpful attorney and provide the judge with all that kind of information. And then if you have any on-point cases that, hit the nail right on the head and say, Your Honor, on these facts, this is what the results should be. Illinois doesn't have bad case law, but there's not a ton of great case law on public housing. New York, I found, actually has some really great case law because apparently the judges there are a bit bolder in reversing the housing authorities for their various actions. So if you're looking for, persuasive case law with fact-specific instances, I'd recommend looking in New York for those cases. So then you got your introduction, your applicable law, a fact section, I think, that said lay out the narrative. You can do citations to the administrative record that's been filed. You don't need to attach your own exhibits all over again, so the judge will just be referring back and forth to the record. And again, there probably shouldn't be any additional evidence because it should all be there in the record. If you have any of your own cases or the administrative plan, you can attach that and provide courtesy copies to the judge later. Then after the statement of facts, your argument, why you should win. Their response brief, their reply brief, then later there's going to be either a status date or an actual oral hearing. Depends how the judge likes to do it. Some judges like to have a clerk status so that everyone can hand in their brief, make sure that everyone met the deadline, get any courtesy copies to the judge, and then the judge will schedule a hearing, maybe a week down the road or something like that. Then you can come in, know the judge has read all the briefs, and argue your case. Or the judge might just set an oral hearing right when she sets the briefing schedule, and you can, do the courtesy copies a week in advance, and then go in and argue the case on that. So that's kind of the way that the litigation of it works. During the oral hearing, you can explain, we stand on our briefs. There are a few arguments I'd like to highlight, answer any questions the judge might have. If they raise any new issues in their reply brief that you haven't had the chance to rebut, you can do that then. Again, since it's your case, you speak first, they speak, you speak, and the judge can then either rule from the bench or take it under advisement and issue a written ruling a little bit later. So any questions about the actual nuts and bolts of the case? Yeah?
I have a question about the administrative record.
I think it depends on what, so the question is whether you want to do a FOIA request or whether it's better to have just this in the record. I think it's a question of what your strategy is. If you want to show the judge that this is a really shoddy work on behalf of the agency, they haven't presented any evidence really to support their case. We've done that in some, like Your Honor, there's not even a transcript of the hearing. How are you supposed to even review this? You have to reverse it. You can't affirm this. Maybe it's best to have less information in the record. I don't think it's ever a good idea, though, to withhold any helpful evidence on your behalf. But again, it has to have already been presented at the informal hearing and entered into evidence there. So even if there's something in the in their file within their agency that maybe should have been presented at the informal hearing, it was actually on our client to get that information and present it then. So even if it's there, even if they knew, if it wasn't presented as evidence at the hearing, it can't come in now. So if you're representing someone at an informal hearing, it really does behoove you to go down there, look through the entire file, find all the evidence that you want, because just because they have it doesn't mean that they necessarily want to present it. You might have your own evidence inside their record that you want to present at an informal hearing. And we can kind of talk about that a little bit later. Does that make sense?
Yes.
Okay. So the different remedies the judge might have, the judge could affirm and say, no mistake here, or, well, maybe not the decision I would have made, but I'm the judge, I don't run the agency, so I'm not going to reverse it, affirm, or completely reverse, big mistake, give them, the benefit back or whatever, or remand, say, it could go either way, there were some procedural flaws in the way that they did this informal hearing, go back, have a new informal hearing, and this time fix these particular problems with the way you did it. Or go back and look into this one question, because that's what I want to know about. If the case is remanded, the court actually retains jurisdiction, and they can go back for a further review of the judge after they've kind of, beefed up the informal the record and kind of made more factual determinations for the judge. The best result for us, obviously, is just reverse, because if we get remanded, chances are the agency will still try to take away the benefit, and maybe this time they'll do a better job at the informal hearing, and we're still kind of screwed. So trying to reverse it just outright is the best result for our client. And if they are reversed, the decision terminating the benefit technically never happened, and so if you've lost the temporary restraining order motion, now all those back payments should be given to your client. So you should make sure it's very clear in the order that the judge enters that they are to pay retroactively to the date that the benefits are terminated. Otherwise, the housing authority or some other agency may not feel they need to do that and only pay prospectively, and then you'd have to come in on a whole other motion to enforce the court's order and clarify it. So just make sure that's clear in the actual order if the judge reverses the agency. Your Honor, can you please direct the agency to pay the benefit dating back to the time it was terminated? The judge should, because they were wrong to terminate the benefit in the first place, so that entitles them to all of that. They can't get any damages or interest on that money because you can't do that against the government, but you can get the benefit back because of the property interest of the statutory entitlement that. So, any other questions about the procedure for these cases? If not, we'll just go right into like the standards of review and what legal mistakes might look like.
1254.
Okay, good. I feel like I'm talking fast, but there's so much information. Any questions at all? No? Okay, I think that's a good thing. So, you're alleging that the agency made a mistake, and you're asking the judge to reverse it. The standard of review depends on the mistakes that you say the agency made. There are a few different types of mistakes that they could make. I break them down, into about, 6. They have their general duties, to give the judge enough findings of fact and conclusions of law to actually do judicial review, and they can't act arbitrarily and capriciously. They can't just go around screwing people. That's not a mistake of law or fact or anything. They just can't do that. And if there's evidence of that, they need to be reversed. Constitutional issues, due process violations. You have the right to not be deprived of property without due process of law, and that right is also there during administrative hearings. So you have the same types of rights at an informal hearing as you would in any court case: to object to hearsay, to have an attorney, to cross-examine witnesses. All those procedural rights that we take for granted in trials should be available to some extent at an agency hearing. Maybe not quite as robust, maybe not quite as formal, but if you believe that you've been deprived of one of those rights and it's prejudiced you, that could be a constitutional violation. Questions of fact, was the sky blue on that day? Questions of law, the interpretation of a particular regulation, of a statute, how it should be applied. Mixed questions of fact and law, to whether this set of facts meets the statutory standard, and sanctions imposed. Did the agency go too far in punishing somebody? So we can just go through those different questions and see how the standard of review works. Again, I'm kind of going with the example of the Chicago Housing Authority. We'll go with the typical case example that Junior has a bag of marijuana in his pocket that the agency found out about when he was arrested and charged, and now there's a criminal record that they've got through their own information request. They sent an intent to terminate the family. They went to an informal hearing. The hearing officer said, yep, we can terminate you for this, and now their benefit has been terminated. What are the different questions, mistakes that fact pattern could raise? So first, the general duties. I'm going to keep going with the CHA. The federal regulations basically separate bases for termination into two camps. There's mandatory termination, and then there's discretionary termination. Mandatory termination is if they're running a meth lab in their apartment. That's like really bad things, and the regulations say if they do any of these things, you have to terminate them. No ifs, ands, or buts about it. So if they commit that crime, sorry, we can't really do anything about it. You just have to go if they meet their burden of proof at the informal hearing. I think there's some immigration problems, some fraud issues. Those are like the higher standards. The other group is discretionary, like this. Caught with a bag of pot in his pocket. That violates the family obligation to not engage in criminal activity, which is in the regulations. If they violate that, they could terminate them. Maybe they don't have to, and they have to consider whether they want to do that. For this standard, our appellate court has said when you're considering a discretionary termination, you have to consider all the mitigating circumstances for that particular case. Was that done? Is there evidence in their informal hearing decision letter that they took into account that Junior is only 16 years old, that he needs to finish school, that he completed probation and community service properly, that there are 3 other kids in the unit, all under the age of 10, that mom has no source of income, and if they don't have this voucher, they're all going to be rendered homeless, that he said he's sorry. You know, I don't know, like, mitigating circumstances that affect how the CHA wants to exercise their discretion. If it's not in the informal decision letter, presumably they didn't even think about it and breezed past it. That violates their obligation to give the judge, you know, actual factual conclusions and legal reasoning to review and make sure that they did everything properly. Same thing for not being arbitrary and capricious. You know, if we ever got an order decision that said, well, what the hell, I don't care, and they terminated the person, obviously that would violate their duty to not act arbitrarily and capriciously. To not be arbitrary and capricious, you just have to have some logical connection between the facts and the not a huge standard of review for, you know, it's very deferential to the agency. All they have to show is some reason for their behavior. So that's just their general duty. And then there's, you know, the standard review, reverse diff. I have a little blurb case law to kind of explain the standards. And here's some examples of arbitrary and capricious conduct. Constitutional issues. So the way this can come up, did the CHA tell the family why they were seeking to terminate the voucher? Were they on full notice of what the problem was for Junior? Did they only rely on hearsay to prove up their case? Was the officer ever present? Was the police report certified so that could actually be admitted into the case? Those kinds of things. Those are constitutional due process problems. Due process, and it's reversed if you have a violation that caused prejudicial error. Even if you point out a violation, if it didn't prejudice them in any way, that's not a basis for terminating or for reversing the agency. So there's 2 components for due process. There's the right to notice, and there's the right to meaningful participation. So notice is basically, was the participant, you know, sufficiently appraised to know what the real charge was. They don't have to explain every single little bit about, well, you know, you did A, B, C, D, and F, and G, but it should provide them enough information so that they know what the problem is and prepare a defense for themselves. Sometimes we bootstrap that requirement to a regulation that says for an intent to terminate for the CHA, you have to provide a copy of their criminal record with the intent to terminate so the person can actually know what the charges are. So then if the CHA doesn't do that and comes back and says, well, maybe we didn't include the criminal record, but it's enough that they knew what was going on, it doesn't violate their right to due process. Sorry, it does violate the regulation, and I would say that if the regulation says this is what's required to appraise the family of the problem, you need to have done that. And the fact that you didn't deprive them of the right to notice and they weren't able to prepare themselves for this hearing. The other component is procedural safeguards. You know, how much procedure are we going to give this person to prevent a wrongful deprivation of their property interests? You may have heard of the Supreme Court case Mathews V Eldridge, where it's Mathews balancing about, and I think there was welfare benefits, I think, or I don't know. But the idea is take the weight of the benefit. In this case, it's affordable housing within the city of Chicago. You can make it as weighty as you want. The weight of the benefit, and then weigh it against what is the cost of additional procedure. You know, what more did you want the agency to do? Maybe you did want there to be a transcript. Maybe you did want there to have them notified of the right to have an attorney. Maybe you did want there to be, you know, to have sustained that objection to the hearsay evidence that was brought in. The cost of additional procedure, and then also consider how likely adding that procedure would prevent a wrongful termination in the future. Weigh all those factors. If it's not that big of a deal for the agency to have provided, it would have been a huge difference to our client. You might be able to argue a violation of their right to procedural due process. Hearsay also, you may have heard the technical rules of evidence do not apply at administrative hearings, which is true. So, you know, maybe they don't have to lay a foundation in order to get a document admitted, or maybe the best evidence rule isn't in force or something like that. But the substantive rules of evidence are still there, and hearsay is a substantive rule of evidence that's pretty important. It can actually rise to due process if the entire case rests solely on hearsay. If there is no independent evidence that the agency has presented except for hearsay, that's a due process violation because you're violating their right to confront witnesses. So that could suddenly rise to a constitutional issue. The other thing is, usually if you don't object to some admission of evidence at the hearing, now you can't object to it on administrative review. I think you could maybe get past that by claiming it's a due process violation, and also the fact that this person was unrepresented and unsophisticated at the hearing. How are they to know the rules of hearsay and to formally object to every offer of hearsay? I don't know how that might play out, but so far I haven't seen a judge be like, you're right, they didn't technically object, I'm not going to consider that issue on appeal. But the argument is there. So that's constitutional issues. Questions of fact. These are the most deferential to the agency because the agency is considered to be an expert in that particular field that they are regulating. So if it's the EPA, you know, is there so many parts per million of carbon within this we're going to defer to the agency on that particular question because they're the EPA, they should know. For the CHA, let's see, what was my, oh yeah, did the family member actually commit the criminal activity? That's a yes or no question. If the CHA found that they actually did it, that's a fact that they have ruled on. There's a part in the CHA plan saying that it's a violation if the criminal activity occurs within the immediate vicinity of the premises. The CHA plan says that is a 1 mile radius around the unit. Did the activity occur within 1 mile or outside of 1 mile? If they say it's within 1 mile, then we have to defer to that factual question. Did they report the criminal activity within 30 days as they're required to do under the plan? These are factual questions. There's a yes or no answer to it. Those are not reversed unless the conclusion is against the manifest weight of the evidence. That standard basically means if no reasonable person would have come to this conclusion, then the judge can reverse it. Obviously, that's very deferential. If there's any basis in the record at all for that particular conclusion, then the judge has to affirm it. The only time I have gotten a judge to reverse a manifest weight of the evidence question is how did this go? Someone was hit in their car, and they didn't have insurance at the time. And the secretary says if you don't have car insurance and there's a likelihood that someone's going to sue you for the damage and it was your fault, then you have to post a bond, and if you don't post a bond, your license gets suspended. That's what happened. The person was in an accident. It actually wasn't their fault because the other side filed a false police report. It was actually her fault. But when you get the police report, it says that all the damage occurred on one side, and yet she claimed that the accident occurred in a way that was completely contrary to the way that possibly could have happened. You know, that if it happened the way she said, the damage should all be on this side, but it's not. That to me means that the opposite conclusion is clearly evident, that it was a physical impossibility for this to have happened this way. To have concluded otherwise, that this was his fault, given the location of the damage, that's a conclusion that's against the manifest weight of the evidence. If you can do a Google Maps and say, Your Honor, I know this isn't in the administrative record, but look, it was 1.5 miles away, not a mile, that's against the manifest weight of the evidence. Notice I will object to that admission of evidence, but it was their burden anyway to say whether it occurred within the radius. Does that make sense, the fact questions and what you have to show? It's the least advantageous area, and that's why you'll see the agency arguing the whole time, Your Honor, this isn't against the manifest weight of the evidence, this isn't against the manifest weight of the evidence. We're arguing the whole time, Your Honor, this has to be reversed because it's a question of law, it's a question of due process violations and things like that, which is a more advantageous ground for us to argue on. Questions of law reviewed de novo. So questions of fact are given deference because they are the experts in their field, but the judge is an expert in reading the law. So the judge can tell us, you know, what that particular regulation requires because they're a judge. The only exception to that is if there's a gap in the statute or in the regulation and the agency has filled in that gap with some definition of its own, then there is some deference to their expertise, but usually, you know, what does the regulation require? What is included in the definition of annual income for a voucher recipient? That's a regulation. The judge can see exactly what that is. Those are reviewed de novo, they're fresh, no deference to the agency whatsoever. And you can use that to kind of limit the agency's authority. If they've acted beyond their authority given to them by this regulation, then they should be reversed. Mixed questions always is really hard for me to understand, and I'm not even sure that this is a real area, but I guess it is, and I should defer to the Supreme Court. But it's when there's a particular set of facts, and the question is, does this particular set of facts meet the statutory definition? The best example I could come up with is the CHA has a regulation saying that the family can be terminated if someone violates their family obligation to not engage in A, violent criminal activity, B, drug-related criminal activity, or C, other criminal activity that threatens the health, safety, and welfare of the other residents in the immediate vicinity. Okay, what is other criminal activity that will threaten the health and safety of the other residents within the vicinity? I don't know. You know, in this particular case, they were dealing heroin. Or no, that was drug-related criminal activity. What was the, I don't know, public exposure? I don't know. Other criminal activity that threatens the health and safety. The CHA says that public exposure threatens the health and safety and welfare of the other residents of the immediate vicinity. Well, that's reversed for clear error. The judge will get to decide, kind of, whether that is going to be reversed or not. The standard is, if it leaves the judge with a clear impression, or what is the exact language? Yeah, after review of the entire record, left with a definite and firm conviction that a mistake has been made. So you just make the argument, Your Honor, are you kidding me? You know, public exposure, threatening the health, safety, and welfare of the other residents, please. So you can reverse it on that ground. And finally, the final section is what punishments the agency can give someone. And this covers everyone. There could be fines, there could be suspensions, who knows what there could be that the agency has handed down. For the CHA, we're talking about terminating the benefit. That's kind of the most extreme sanction that I can imagine. That sanction for a violation is reviewed for reasonableness, which isn't actually as helpful a standard for us as what we would like. It's just reviewed for whether they act arbitrarily, capriciously, and abuse their discretion. Again, there has to be some logical connection between the violation of the facts and the agency action. So if the judge reverses it on that ground, the judge can't decide, you should have terminated their voucher, you should have fined them $2,000. The judge can't order them to do some other kind of sanction, but the judge can remand it for consideration of some lesser sanction if they think that that was too far. And Ian just had a case where that happened. So, yeah, in Ian's case, the poor lady was in a unit that continued to flood. She was told she had to hire, cleaners to clean up the carpet, which cost hundreds of dollars. Her landlord advised her to not pay rent to offset that, but it was a large management company, and wires got crossed, and they filed an eviction action against her for non-payment of rent, even though they told her to. Not paying your rent is a serious violation of the lease, which is a family obligation, and you can be terminated for it. So she's basically terminated for following her landlord's instructions, and the landlord even wrote a letter saying this was a big mistake. They decided that terminating the family when they were 2 minor kids, one little girl, when they would have been homeless was a good sanction. The judge said, no, that is too much, but go back and consider a lesser sanction. So that's about it. Those are the standards of review. Those are the way you can argue the case. And then just at the final section, we do a lot of CHA and HACC, which is the Housing Authority's Cook County cases. You can see the different regulations there. Usually the way I like to argue it is to find the regulation that's most advantageous to my argument and go with that. It could be in the plan, it could be in the federal regulations, it could be in the act. You know, I can have some wonderful flowery language about the purpose of the program is to provide quality quality affordable housing for low-income people, and the agency is supposed to be furthering that and doing what they did to this poor family's not in furtherance of that. You can find different authorities. Just understand that it does technically go in that hierarchy that I explained before, that the highest is the Housing Act and goes on through. Administrative plan could be found online. You can just Google HACC Administrative Plan, CHA Administrative Plan. We did once have a really hard time finding the Oak Park Housing Authority Administrative Plan, but eventually we found it. So that's where you can find the regulations. The general approach I would suggest for these cases is starting with what was the violation. that the agency said they did in the termination notice. Look to see whether that is the violation that was litigated at the informal hearing. If the informal hearing went way beyond the notice, that could be a due process violation. And then compare, what the evidence was presented at the informal hearing to what the regulations would require, and decide whether it should be reversed or not. Our cases have already been vetted. We believe that there is an argument to be made. The CHA actually handles their cases relatively well at their informal hearings, and usually it comes down to whether they exercise their discretion well enough. Usually there is some valid basis for terminating the benefit. If there wasn't, their own internal quality control procedures, whatever, probably would have caught it by now. And there probably is some basis for their action. The question is, is this really, are we going to go this far for this particular violation? Did they support their conclusions in the informal? Okay, does anyone have any informal questions? Does anyone have any questions about all that? There's a lot of information, I know. First thing, I think they're really fun. I'll do a small plug for these case types. They're very self-contained. There is no discovery. There are no depositions. If you get them from us, we've already vetted them and teed up the legal issues for you, so you can go in on briefing and just brief out the issue. The record is closed. There's no motion practice unless there needs to be a motion for temporary restraining order. Even that we can handle ourselves if you prefer not to do that, although I think it's fun to do those too. And then you just brief it. It gives you great legal research and writing experience. It gives you a taste for an appeal, because it's basically a mini appeal at a different level. You get exposure before the judge. You get to argue for the judge. The other thing is we have actually a really great working relationship with the Chicago Housing Authority and with the Housing Authority of Cook County. If it turns out that we need to reset the briefing schedule, we can probably do that. If we are missing something from the administrative record that should have been filed, we can probably just give them a call and say, hey, do you think it should be in there? I think we're all public interest-minded people. They are looking to serve the public just the way that we are. Their mission is to ensure the integrity of the housing program, because there are thousands of people trying to get affordable housing in Chicago, and if they believe they have someone who's not following the rules and there's a family who is, they want that family to go and get that voucher. Our argument is, well, these are the people who have built a life based on this voucher, and if you're going to terminate them, you better be sure that what you did was correct. So, in a sense, we're all on the same side. It's very collegial, very fun. I like them. Yeah. This is the Access to Justice program. I think on your original, if you did a volunteer orientation, you probably checked what programs you're interested in, and then you'll have been put into those programs. If you want to add new programs, who are you? Do you have a point person yet? Oh, great. Okay, then you're probably already in the program. If you actually want to do these case types, I have my contact information, and you can just email me, and we'll keep you in mind. Because basically the way that this program works is we're not posting all these cases online for you to shop through and decide whether you want to take it or not. We actually reach out to you and say, hey, I remember you're interested in an admin review case. We have one. Here's a case memo. Usually the case memos are around 3, 4, 5 pages long. You can read the case memo for yourself, look through the administrative record, decide whether it's something fun you would like to do, and then so the short answer is just give me your contact information. Yes, so long as you have a supervising attorney. So you can do the legal drafting, you can do the research. It would just need to be an attorney's signature on the actual filing. And you can argue the case in court. I think you can do, I don't know if you need to have a supervising attorney in the courtroom with you.
I always take one with me.
Yeah, I don't think it hurts. But yeah, if you want to take it, and if you have an attorney who wants to supervise you, I might be able to supervise you, I don't know. We'd have to check into that. I think to get your license, you have to already be with a nonprofit, I think. So I think it would have to be a supervising attorney from that nonprofit. If you volunteer in these cases, you'd work directly with me or with other people in our particular program. So we can have hour-long conversations to hash out legal arguments. What are the different angles you want to take on the case? You can send me your drafts to review and decide whether this is compelling to me. And you can even have us proofread them if you really want. Also, if you have some issue that you need to reset the briefing schedule, we can reach out to opposing counsel. We're basically your partners in this volunteering. It is your case, it is your client. You should feel whatever you need to do to represent them well. But we are at your service. Any other questions? Great. Well, thank you for coming. Obviously, you have the outline. The next seminar is filling out your 2013 tax returns, and that is on February 19th. So mark it in your date book. And let's see, there's evaluations up here. If you want to kind of give us a sense of how we did, please fill that out because it is helpful to us. We do read them and adjust the way we do things for that. Since you have signed in, we're going to just kind of presume that you are interested in these case types. If we contact you and you're not, fine, let us know. But technically, the trainings we provide are hopefully for people who are interested in volunteering with us. You will get CLE credit, of course, regardless, but that's kind of hopefully the investment that we're making in these trainings. So we hope that you'd be interested in volunteering. Okay, signing off. Yeah.